5 seconds to go. Start. The trial court thereafter framed the following issues. Is the suit triable under the provisions of the WBPT Act 1997 or the Transfer of Property Act 1882? Whether the suit is maintainable as framed or at all. The trial court in all four suits answered the issues in favor of the plaintiff primarily on the ground that since the tenancy subject matter of the suit was created with effect from 20th November 1992 and the Tenancy Act came into force with effect from 10th July 2001. The agreement inter se the parties therefore was governed only by the TP Act. The observation of the trial court is extracted as under. It is pertinent to mention here that the lease deed was executed on 20th November 1992 for the period of 99 years and the WBPT Act 1997 came into force on 10th July 01, that is much more earlier than the enforcement of the WBPT Act 1997, and there is or was no express word in the WBPT Act 1997 that all right accrued by any party from the prevailing any law will be extinguished since the WBPT Act 1997 came into force on 10th July 01. Therefore, it cannot be said that the present suit squarely governed by the TP Act and not under West Bengal Premises Tenancy Act 1997, and in view of such factual aspect, the present is perfectly maintainable. It is in appeal from such order of the trial court that the impugned judgment with particulars as noticed above came to be passed. The High Court, while upholding the jurisdictional issue in favor of the respondent tenant, dismissed all the four suits of the plaintiff for the same not to be maintainable. Thus, the issue, as already observed, is as to whether the order passed by the High Court holding the respondent tenant to be governed by the Tenancy Act is legally sustainable or not. In these special leave petitions preferred by the landlord, notice was issued on 17th February 2020. During the course of the hearing on 15th February 2024, petitioner applicant landlord had offered time to the tenants to vacate the premises. Certain suggestions for amicably resolving the dispute for all times to come were exchanged, and as such the matters were adjourned. We are now informed that the petitioner landlord's offer of giving time to the tenant to hand over the vacant possession of the premises stands rejected. Thus, the landlord insisted on the disposal of the applications, asking the tenant to pay the rent at the market rate for the lease to have been determined at the institution of the plaint. The interlocutory application bearing the above particulars has been taken as the primary application for the sake of facts. It is noted that similar applications seeking similar prayer have been filed in other special leave petitions which shall be disposed of in accordance with this order. We notice that these applications in issue have been pending for almost 3 years. The applicant petitioner in the SLP seeks direction for payment of monthly occupational charges following the prevalent market rate. The prayer as made is reproduced below. Stop.